Good evening, and right before we dive into the main story, I'll quickly mention that if you are sick and tired of all the censorship on this platform, as well as the myriad of other platforms out there, and if you're looking for a source of actual honest news, well, you're in luck. You can now check out the Epoch Times because we recently extended our awesome sale on subscriptions. Just 25 cents a week for the whole year, which if you do the math, works itself out to just be a single dollar a month. And so if you're indeed looking for a source of honest news, which oftentimes gets completely blacked out by the mainstream legacy news outlets, well, consider trying a subscription for yourself. I'll throw a link to the sale page. It'll be right there at the top of the description box below. I hope you check it out. Now, diving into today's main topic, there was just a massive victory for the Second Amendment over in the U.S. federal court out of the Southern District of New York. Specifically, a federal judge there, he gave a legal beatdown to the city government, and he ruled that the laws putting onerous restrictions on gun licensing are indeed unconstitutional. And even though technically this was a New York case, the ramifications of this decision will be felt in blue cities and blue states across the whole nation. However, let me set the stage for you properly regarding what this case was really all about. Back in the year 2018, a man by the name of Joseph Srouwer went to the New York City Police Department and he applied for a handgun license and in the following year for a long gun license. However, both of his applications were denied. Mr. Srouwer then appealed both decisions, but again, his appeal was likewise denied. And as ridiculous as it might sound, the reason that the government gave for denying his request to exercise his Second Amendment rights were severalfold, including, for one, that he had a bad driving record, and secondly, because he did not pay his tickets on time. Here's specifically what one court document said regarding the matter. Quote, like the original denials, the affirmance on the appeal pointed to Srouwer's arrest history and his poor driving history, specifically finding that the latter shows a lack of moral character. These reasons track the language of the relevant New York law, which at the time required that the licensing official's determination that an applicant, quote, lacks good moral character or that other good causes exist be based on factors to include the applicant's arrest history, poor driving history, and other history that demonstrates an unwillingness to abide by the law. Meaning that when Mr. Srouwer went to get his gun licenses, the government official reviewing his application, he had the authority to determine whether this American citizen had good moral character, and among the things that he could use to make that determination was to see whether or not he had a good driving record. Just a really good reminder of how far we've actually come from 1791, when the Second Amendment was first ratified, in order to make sure that our gun rights shall, quote, not be infringed. Regardless, though, you fast forward 230 years, and that was the situation. Mr. Srouwer was denied his licenses, and as a result, he filed a lawsuit against the city, arguing, at least in part, that, quote, an individual's driving history has no cognizable, historically recognized basis as a prohibitor to the possession, purchase, or use of a firearm. However, this is where things, you can say, got interesting, because during the course of this lawsuit, as it was making its way through the legal system, it was at this time that the U.S. Supreme Court decided to take up another gun rights-related case, which was New York Pistol and Rifle Association versus Bruen. This was another case, also out of New York, challenging the legality of the concealed carry permit requirements. And so once the U.S. Supreme Court accepted the Bruen case for review, the parties involved in the Srouwer case, they agreed to put a pause on the case, to put a stay on the case, pending the outcome of the U.S. Supreme Court. They wanted to see what the U.S. Supreme Court ruled in the Bruen case in order to see how it's related to this case. And indeed, as we've discussed on several previous episodes, the U.S. Supreme Court, they wound up ruling in the Bruen case against New York. They invalidated New York's entire shall-issue system of concealed carry permits. And thirdly, the U.S. Supreme Court created a new legal standard for gun laws across the whole country. Moving forward, state, local, and federal governments, they must prove that their restrictive gun laws, quote, are consistent with this nation's historical tradition of firearm regulation. And if they can't prove that, it means that the law is by definition unconstitutional. Now, you would imagine that this Bruen decision pretty much solved the whole problem that Mr. Srouwer was facing. However, you would be wrong, because following the Bruen decision, the governor of New York, Ms. Kathy Hochul, she called the state legislature of New York into a special session, and they passed a new set of laws which allow the state to deny people gun licenses if they determine that an applicant has bad moral character. Quote, almost immediately, Governor Kathy Hochul called the legislature into session to pass the Concealed Carry Improvement Act. The act removed mention of proper cause, but expanded all other requirements. An applicant's social media will be scrutinized, and he or she must provide contact information for a list of close family and friends. There were similar laws passed in New York City as well. And if you're wondering how these government officials will determine whether or not you have good moral character, well, according to the law, when you apply for a permit in New York, you have to give the government officials 3 years worth of your social media history in order for them to look through it and determine whether or not you have good moral character. And of course, given the fact that this is New York, well, you better hope that you didn't publicly support a certain candidate during the 2020 presidential election. Essentially, at the heart of it, what happened was that since the Bruen decision overturned the law, which stopped people from getting permits, instead of complying with the Supreme Court decision, the government of both New York State as well as New York City, they just put up new window dressing so that it appeared that, at least on the surface, they were complying with the decision, but underneath, the effect was the exact same, denying people their Second Amendment rights based on the sole discretion of some government official who makes the determination of whether or not you have good moral character. And so, because of these new laws, the court allowed Mr. Strouder to amend his earlier complaint and to actually challenge the constitutionality of New York's new requirements as it relates to concealed carry laws. And so Mr. Strouder and his legal team did just that, and they were arguing that these new laws have no historical precedent in American legal tradition, and therefore they are in fact unconstitutional. On the flip side, however, quote, the defendants in the case, New York City and the NYPD Commissioner Kichan Sewell, cited 18th century laws in New Hampshire and Massachusetts that allowed authorities to arrest and disarm people for certain offenses in an attempt to show historical analogs for the regulations. However, the judge in the case was not buying that argument. Specifically, after many months of legal back and forth, the federal judge in the case, he ruled against New York City, finding that the gun licensing regime does indeed violate the Second Amendment. Specifically, in his 48-page ruling, Judge John Cronin, who was, for your reference, appointed to the bench by President Trump, he wrote the following, quote, much like the proper cause inquiry invalidated in Bruen, permitting denial of a firearms license based on a government official's good moral character or good cause assessment has the effect of preventing law-abiding citizens with ordinary self-defense needs from exercising their right to keep and bear arms. Relatedly, and probably more problematically, by allowing the official to make a determination of the person's moral character and to vaguely consider other good cause, the new law further bestowed vast discretion on licensing officials. Here too, the fatal problem with the new law and the former versions of the law continues to lie in the broad discretion afforded to city officials in determining whether someone may exercise their Second Amendment right. Defendants have not identified any historical analog for investing officials with the broad discretion to restrict someone's Second Amendment right based on determining the person to lack good moral character or for a vague and undefined notion of good cause. And as such, the judge overturned the moral character requirement that was in place. And now, before we move on to what the plaintiffs had to say regarding this decision, let me quickly introduce today's sponsor by showing you this little piece of money. Or rather, I should say that this is fake money being printed into oblivion by those geniuses over in Washington, D.C. And so before they completely obliterate your life savings, what I recommend you do is to convert that fake money into real money, which is physical gold and silver. And the best company to use is the sponsor of today's episode, American Hartford Gold, who also happens to be my own personal gold and silver bullion dealer. They have thousands of other 5-star ratings across the country. They have an A+ rating with the Better Business Bureau. They ship quickly, directly to your doorstep. Their product listings are awesome. They're stacked with great options of gold and silver bullion and coins, and they have amazing customer service. When you pick up the phone and call them, you feel good knowing you support a company that supports the truth getting out into the wider American audience. And so calling them up is a no-brainer. But best of all, if you tell them that Roman sent you, they will throw in up to $5,000 worth of free silver with your first purchase. It's 866-242-2352, or you can simply text the word Roman, R-O-M-A-N, Roman, to 65532. Of course, all their details will be down in the description box below. And now, let's head on back to the studio. And as such, the federal judge ruled that New York cannot deny gun licenses based on the applicant's moral character. And as you would imagine, the plaintiff in the case, Mr. Strouder, was pleased with the decision. We here at the Epoch Times were able to get a hold of his lawyer, and here's what he told us. Quote, the court's decision was true to the text, history, and tradition analysis that began in Heller and continued through McDonald, Saitano, and Bruen, which for your reference are different Supreme Court decisions. He further added that once the case goes to appeal, he expects a favorable ruling based on the facts. Quote, we expect a consistent ruling in the Second Circuit. Discretion simply cannot be woven into the government's regulation of arms. And so, there you have it. Another victory on the pro-gun rights side in the never-ending battle over the Second Amendment. If you'd like to go deeper into this particular case, I'll throw all my research notes. They'll be down in the description box below this video for you to peruse at your own leisure. And then lastly, as I mentioned at the top of the episode as well, if you are indeed sick and tired of all the censorship on this platform, with or without the federal government's direct involvement, well, you're in luck. Because, as I've mentioned earlier, the Epoch Times has recently extended its awesome sale on subscriptions. Just 25 cents a week for the whole year, which works itself out to just be $1 a month. And so if you've been on the fence about subscribing, you aren't sure whether you're ready, but you're definitely sure that you're tired of the censorship and you're looking for a source of honest news, well, perhaps take this sale as an opportunity to try the Epoch Times for yourself. That way, you can get access to a phenomenal treasure trove of content, including I myself publish anywhere between 1 to 3 exclusive episodes of Facts Matter over on Epoch TV. And so if you like to watch some extra episodes of Facts Matter every single week, including a huge backlog from the last 3 years, well, you can find it all over on the website. I'll throw a link to the sale page. It'll be right there at the top of the description box below. You can just click on that link and it'll take you to the sale page where you can try the Epoch Times for, again, just a single $1 a month. Now, of course, you can cancel any time, but I'm sure that you won't. I'm sure that you'll fall in love with it and be a subscriber for a long, long, long time to come. So again, that link is right there at the top of the description box below. I hope you click on it, and I hope that you join us over on theepochtimes.com. And until next time, I'm your host, Roman from the Epoch Times. Stay informed, and most importantly, stay free.